Sheikh Abdullah's speech has been read, but this is their understanding in the absence of a merger agreement. As I indicated earlier, Manoj, the 370 is in the nature of establishing the relationship I've highlighted. This arrangement involved a division of sovereignty, which is the normal feature of the dominion. The state enjoyed complete residuary sovereignty, which is what is reflected in the JK Constitution. So, my lord, the state lists, my lord, as far as they are concerned. Then, my lord, when the draft constitution, my lord, was introduced, I'm coming to, my lord, 11.25 at 231 and 232. Just at 232, my lord, just above 11.26. By this I mean that all these special constitutional privileges which our state enjoyed prior to 1953 are enjoyed by her even today. In other words, the state enjoys the same kind of autonomy which it stood prior to 1953. Therefore, to say the instrument of accession wiped things out, my lord, is simply not correct. Now, my lord, 11.28, I've already read it out to your lordships, my lord, because it imposes a limit. One question that was put, can 370 be amended or not amended? Is it there permanently? Mr. Sebal said that's not before your lordships, but at any rate, it may not have been a sufficient answer. There is a proviso, my lord, that was added by CO 48. CO 48 is a foundational document, my lord. And that is at 11.28, provided further that no such amendment shall have the effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of 370. In other words, after you go through the amendment process.
Yeah.
Now, my lords, can this proviso,
Somebody's cell phone triggered.
what has happened is, my lord, when the microphone was on, some things emerged there which I didn't want to emerge because I was talking to my colleagues. I hope they will be excised.
That's what I went to him and told him that your whispers are also being recorded.
My Lord, we will deal with all that, my Lord. With a pinch of salt, my Lord.
But it's quite accurate. Huh?
I shudder to think, my Lord, if this was the case when we were arguing Babri Masjid, what would come in the transcript? Such a huge amount of exchange took place, my Lord. Now, my Lords, therefore, my Lord, how do you amend the 370? You amend it through the 368 process. But there was in CO 48, my Lord, a provision that you will then go to 370 and follow the procedure in 371. And that's very important, my Lord. Your Lordship asked, what was lost on the 4th of August? This is something that was lost. And they didn't even use the amendment power, which is the only power available to them, my Lord, to delete 370, not the circuitous process that they used in 272 and 273.
Yes, Dr. Sir.
Now, my Lords, on 235, 11.32 onwards, my Lord, your Lordship conferred, that took time as well. Happy though I am that your Lordships did, my Lord. My Lord, I'm going to be super quick, my Lord.
Yes.
Just give me that indulgence. Now, my Lord, here are all the cases. Your Lordship needs to go through Premnath call, which I've summarized, my Lord, in 11.33. Because it actually explains what the situation was after 1950. When there was an instrument of accession, but no merger agreement. On page 236, my Lord, my submission, my Lord, from Premnath call is application of 370 of the Constitution to the state of JK also does not impact the plenary powers of the Maharaja. The form of the Constitution to be applied to JK was a matter left to be determined by the State Constituent Assembly, and until such decision was taken, the constitutional relationship between the Union and the states was governed by the terms of the IUA. So the internal, my Lord, relationship had to still be determined under 370. Now, my Lord, an argument has been made on the basis of Puran, Lakhampal, etc. What is the meaning of modification? And they say it's very wide. But, my Lord, your Lordship has to read it in context. And that is when the matter was not referred to the 7-judge bench, my Lord. Your Lordships took the view that please read these decisions in context. Don't read them outside the context. Now, my Lord, I'll come to 370, my Lord. What I've done in the meanwhile, my Lord, is done a short page and a half, my Lord. But I'm not giving it now because your Lordship may introduce the guillotine earlier. Now, my Lord, kindly come to 370.
Does that begin at 239, Dr. Dhawan?
Sorry, my Lord.
Is that? Oh, sorry. I thought you were referring to your submissions.
My Lord, I'm not going to repeat what's in the submission. I'm going to just, my Lord, stress what is not in the submission, which I've stressed orally.
Fair. Yes, Doctor.
Now, my Lord, we need not be troubled with the provisions at all, my Lord. That has been the great, my Lord, call. This is a temporary provision. It's temporary to the extent that 370 indicates. Therefore, my lord, in my personal view, my lord, 370 subclause 2 and 3, which deal with the Constituent Assembly, my lord, have become motives. They have invoked this, my lord, in CO 273. All of a sudden, a provision, my lord, which is constitutionally beyond the extension of the Assembly, has suddenly been used in CO 273. That, and I think it's CO 44, is it? 44 is the only time, my lord, 370 subclause 3 was used. In 1952, and now, my lord, in the year 2019. So, my lord, what remains, my lord, after the Constituent Assembly? In our submission, what remains is 370 subclause 1. Not to be read as a statute, but to be read in context. And what are the provisions here, my lord? I'm not going to read them out, it's been read ad nauseum, my lord. It says, follow the instrument of accession, my lord, as far as consultation is concerned. For the rest, there must be concurrence. And the same is true, my lord, of D, 371D. Those provisions, my lord, are governed by the two provisos. Which then talk of consultation and concurrence again. The reason why I said, my lord, that 370 could not be tinkered with during President's rule is because there is a mandatory requirement, as it was in Article 3. About consultation and concurrence. You can't say we wiped out the Constitution, we wiped out all the treaties, so that 370 is gone. Amend it, go through that particular process. But by this circuitous route, my lord, mandatory provisions which survive in 370 subclause 1 are violated. And they can't be done under President's rule for a very simple reason. Because it says the state government, my lord. Consultation with the government of the state is declared by the President to correspond in such matters. Other matters in such list with the concurrence of the government of the state. Of course, provision 1 in this article shall apply in relation to the state. And then, my lord, once again in D. Now, my lord, can we wish this away by some circuitous route? 370, by far from being a relic, my lord, is in fact what is there in the merger of agreement read with the instrument of accession. In fact, my lord, I say this is part and parcel, my lord, of the multiple federalism that exists. You can't use these provisions, my lord, without subjecting them to the discipline of Article 370. And that's what Damnu, my lord, Damnu, your lordship will get the also says you can't do it. So, my lord, I come back to my broader proposition that while President's rule was in operation, you could not use Article 3 because you can't substitute one legislature for another. And you can't, my lord, do away with 370 for a very simple reason that mandatory provisions of the Constitution do not say that Parliament can do this and the President can do this. It says it must be done by the government of JK, which is not, my lord, the ersatz government of JK, but in 272, it says with the Council of Ministers. And that is fundamental to the operation of any government. So you don't do it with the Council of Ministers. Can you do it simply, my lord, the way it was introduced in Parliament by Mr. Amit Shah? That you simply do it by saying, we're using 370 and this is how it's done. In President's rule, my lord, it cannot be done. There is no tearing hurry, my lord, in our Constitution to say that the amendment power can be used and abused whenever you want it to. Now show me the. My lord, I want to show quickly two decisions, my lord, on why the merger is separated from. It is in volume 6, my lord, of the cases. And the case is Pramod Chandra Dev. It's at page 1587. PDF. And I want PDF 144. The steps that were required. And I'm saying that this, in fact, is in a sense, my lord, the merger agreement is really what 370 is. Now, my lords, I'll take your lordships to page 1596.
Dr. Dhawan, which volume?
Sorry, my lord, volume 6. Cases, volume 6. Item number 10, page 1587. PDF. 135. It starts at 135, and I'm taking your lordship to 1596 at 144. My lord, this is in para 10 on page 1596, my lord, the bottom of the page, my lord. This was, my lord, some.
What PDF page will that be actually?
144.
144.
It says of the instrument of accession, Lord, in the last 5 lines of page 1596. Does your lordship have it? This accession, that is, instrument of accession, did not affect the continuance of sovereignty of the rulers entering into the agreement, save as provided by or under the instrument of accession. So there was no external sovereignty was lost, my lord, but internal sovereignty, my lord, remained where it was. And then, my lord, going over the page at 1597, my lord, 4 lines from the top, the second step was the signing of what has been termed the standstill agreement, the form of which appears in the white paper. And the acceding state signed the standstill agreement which provided for the continuance in time of all subsisting agreements and administrative arrangements in the matters of common concern between the states and the Dominion of India. The first phase of the process of integration of the Indian states into the Indian Dominion was the accession of the states as aforesaid. The second phase followed on the merger of the states into the Dominion of India as a result of the merger agreement. Now, there was no merger agreement, my lord. So where was the merger agreement, my lord? Either we continue the sovereignty, it was said, my lord, in Premnath Call, or we say that this is the essential step by which, my lord, internal sovereignty and internal arrangements are worked out. Then it says, my lord, a little further down, but 4 lines below that, my lord, as a result of the merger agreement signed by the rulers of these states on or after 14th December, but before the 1st of January 48, the Dominion of India was vested with sovereign powers and the ex-rulers were left only with their private property and their annual privy purses. This was the effect of the merger agreement. And it's all there in the white paper of the states, my lord, which I don't want to go into. So where was this loss, my lord, this arrangement of internal sovereignty worked out? In Article 370, my lord. The only two other states were Hyderabad and Junagadh, my lord, they stand on a footing of their own. And that is why, my lord, I emphasize that 370 is the repository of the merger agreement read with the instrument of accession. In this very volume, my lord, I want to refer to one other, which is the first Privy Persons case, my lord. It starts at
PDF?
PDF 390. And I want to take your lordship straight away.
And the instrument of
Of course, the amendment came later in taking the Privy Persons Amendment power away.
page 3.
So, my lord, we're still on volume 6, my lord, and I'm taking your lordship to PDF 457. Just one small paragraph. Paragraph 111 on page 1909. PDF 457.
Referring to paragraph 11, Mr. Awad?
May I read out, my lord? Para 1 and 111.
Yes.
The plea raised by the union must be considered in the light of these developments. The political developments and the history of negotiations and agreements were certainly not intended to be an exercise in futility. The argument that the parties to the instruments were entering into a solemn undertaking intended the arrangements to be temporary and likely to be set at naught by the unilateral act of the Union of India must be rejected. This is building on Mr. Sibal's argument, my lord. A unilateral act, my lord, the assumption you don't take into account history. So the argument raised by the union that this is an exercise in futility going back, the response is the argument that the parties to the instruments were entering into solemn undertakings intending the arrangements to be temporary and liable to be set at naught by the unilateral act of the Union of India must be rejected. I'm actually done. Submission, my lord, which I will hand over and go through it. One of my arguments, my lord, whether it is done by transformational morality, my lord, because of the antecedents, or whether it's done by basic structure, or which transformational morality, in my view, is a part. That 370 to that extent is part of the basic structure. As a substitute for the merger agreement, as an interpretation, my lord, just hand over that. $356, my lord. Where is it anyway? My lord, I'm coming back to volume 1 of the submissions. The PDF number is 267. My lord, I put in a table to show how President's rule has been exercised and Section 92 has been exercised. My lord, it is my respectful submission. They cannot be exercised in tandem. As it was, my lord, governor's rule had taken place, and now president's rule was imposed. On that, my lord, if your lordships will see, I've given, my lord, all the cases that I want to cite. I won't bother your lordships with them. Except, my lord, page 276, which is PDF 276, 4.25.
I'm sorry, Mr. Dhawan, what are you referring to?
Not my submission.
Your latest submission.
I'm now winding up, my lord,
Page number
mercifully.
270.
276.
276.
An important aspect, my lord, Bomai, of course, is there. You can't remember that in Bomai, my lord, it was just the action of presidents. 32 was not involved in the same extent. But I'm relying on 4.25, Rameshwar Prasad's case. Has your lordship got it, my lord?
Yes.
It is open to the court an exercise of judicial review to examine the question whether the governor's report is based on relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. This, my lord, is what your lordships have indicated on the extent of judicial review. Now, what has happened in this case, my lord, and your lordships, my lord, as a Nagaraj can lay down conditionalities for the exercise of 356, all the documents must be made publicly available and placed before Parliament. In this case, even the governor's report, my lord, was not placed before Parliament or before the court. So when your lordship, my lord, says 356 is justiciable, what are the contours of this justiciability? A full, frank, and complete disclosure to Parliament and to the people. Just to say that this is, I've received this message, there it is, and not even to place the report. That is why I say, my lord, the entire exercise of President's rule needs to be examined by your lordship in this case. Others will argue, my lord, more on this when their turn comes. Now, my lord, I'm going to give your lordships my summary, my lord. Give it to the other side. Because this, my lord, is the substance of what I've added to my written submission. May I read it out, my lord?
Yes.
Yes.
India has a multi-symmetrical constitution to be interpreted as transformational in nature. It's unique. And that is why your lordship insists on these transformations, despite the many amendments, despite the length. This is a multi-symmetrical constitution. My second submission, the instrument of accession represents, subject to conditions, the loss of external sovereignty. However, standstill and merger agreements finalizes the internal sovereignty arrangement. And that, my lord, is to be the internal sovereignty arrangement is to be found in 370. 370 is the result of a binding historical agreement. The instrument of accession deals inter alia with conditions of external sovereignty, but in the absence of standstill and merger agreements, 370 represents a substituted, constitutionally consecrated measure agreement for finalizing internal and external sovereignty, resulting in two interactive sui generis constitutions, unlike any other states. It is unique and part of the basic structure entrenched in democracy and federalism. For basic structure, my lord, read transformational constitutionalism. 371 alone survives, and 372 and 3 have exhausted their invocation. Why is this important, my lord? Because, my lord, after 1954, the first time 373 was used was in 273. The provision is gone, the Constituent Assembly is gone, and the substitution is for the Constituent Assembly, the legislature of the state. How can you resurrect, my lord, 370 subclause 3 all of a sudden, years later, after the assembly is over and there is a JK constitution? Now, my lord, as far as the width of power under 1D is there, my lord, it's subject to constraints. I needn't say more than what has been said before. It's subject to its two provisos, and for the rest of the constitution, consultation and concurrence. Now, my lord, Article 3, 4 and 370 contain mandatory requirements on information to be laid before the House and inter alia requiring concurrence and consultation. Unfortunately, the mandatory requirements of Article 3 for sending the bill to the legislature was suspended by the presidential proclamation of 19th December 2018, which is ultra-vires and taints both the declaration and the extension of President's rule in 2018 and 2019. Then, my lord, on President's rule, the President's rule provisions of 356 and 392 and Section 92 of the JK Constitution can not be imposed in tandem. 3 and 4 and 370 cannot be invoked during President's rule at all, since they require the existence of a legislature and state government, for which the President and Parliament cannot be constitutionally countenanced. Then President rule as required by S.R. Bomai and Rameshwar Prasad is justiciable, requiring objective basis, which includes the governor's report, and all material should be placed before the people and Parliament justifying itself.
Formulated very well, Sarah unka jo. I was just telling my colleague that you have really summarized very precisely all that you have argued. We've taken down what you have argued, but now this formulates.
We read it out, Manoj.
Certainly, certainly.
And then I'll sit down. And that's a promise. Now, my lord, Article 370. So I've said all the materials, my lord. Article 370 can be amended, subject to the caveat in CO 48 that all amendments relating to JK must follow the procedure in Article 370, subclause 1. It is not enough in 273 says all treaties are out and the Constitution is gone. How can a constitution disappear like this, my lord? Many federations, my lord, have two state constitutions, and JK, because of its nature, my lord, did. Accordingly, 272 and 273 are invalid as being excessive, and the JK Reorganization Act 2019 under 3 and 4 as going beyond the mandatory provisions and in violation of the process of Article 3, wrongly suspended by the presidential notification of 19th December. Now, my lord, I ask, my lord, answering your lordship's question, what was lost in
Yes,
4th of August?
that's point 9.
Mr. Zafar Shah, my lord, will give your lordships a detailed account.
Itemized list.
This is my summary account. What was lost? The loss of statehood by degrading it to union territories. That was lost. Indirect abolishment of the JK Constitution. Loss of residuary power. Loss of territory contrary to the JK Constitution, Section 3. Section 4, sorry. Abolition of mandatory, informatory, concurrent, and consultation provisions. Conversion of statehood into union territories without adequate safeguards, especially for JK and Ladakh Constitution, without a proper amendment and consultative process and concurrent procedure of Article 370, for which CO 48 was added to 368. The right of permanent residence of JK on their right to property and to vote. Because 31, my lord, Article 31 was not suspended, only the later Article 31 remained. In the light of the above, it is pleaded restore statehood to JK, permit the continuance of the JK Constitution, have immediate elections under the JK Constitution, abrogate presidency. So this is what I had to say. I'm sorry I've stepped over my time.
Thank you, Dr. Dhawan. Thank you very much, Doctor. Yeah.
Allow me to begin with this, Lord, profound words of Justice Aaron Barak, Lord, the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review as way back in 2002. Since, Lord, we are expounding Constitution, Lord, these are extremely apt words. And I quote him: the task of expounding a Constitution is crucially different from that of construing a statute. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework